The mayor keeps insisting that the EPP, that the city is not legally bound by this. What does he mean by that? What does he mean by that?
Well, I think he's referring to Court of Appeals case where the city was sued by a number of employers in the pre-kindergarten industry when bids came out with the EPPs in 2006. That's an industry that's never had any EPPs, unlike this industry, which has had them since 1965, and where there's very low union density, so unlikely that there will be a costly strike, which is one of the factors that you look at. And in that case, we were concerned that the city didn't understand the standard that the Court of Appeals would apply, that if they looked at the project labor agreement cases, they would see that it's sort of very fact-specific, so you had to put facts in the record. The city refused to do that during all the years of the litigation. At the end of the day, the Court of Appeals ruled that on that inadequately developed record, where all the city had to do was prove either that it saved money to have the EPPs, in which they've been saying it has for 40 years, or that it would avoid a costly labor strike like the one in '79 and this one that you see right here. Because they didn't do that, this EPP, this particular bid in this industry on this set of facts did not comport with the competitive bidding laws. Didn't say that the next EPP, like the next project labor agreement, which the city has dealt with, would be legal. Each case, like the project labor agreement cases that the Court of Appeals has ruled on, some are found to pass muster, some aren't. The ones that aren't have to be redone so that they do pass muster. And if you have another minute, let me add two other points. The city also, during the course of the litigation, proposed legislation in Albany to require the Board of Ed to put EPPs in all the contracts, and that would have resolved this issue and avoided all the litigation and the strikes. Once that passed the Assembly and the Senate, unanimously in the Senate, the city then asked the governor to veto the legislation that it had proposed. Articles in the New York Times about that, and about how they, did a 180 on their own legislation. But interestingly, in the letter that the city wrote to the governor, they didn't say that the EPPs are illegal. They simply said the Board of Ed shouldn't be required to have to put them in every case. They should use their own discretion whether to put them in every case or not. And the last point I want to make, give me 30 more seconds, is that the mayor and the chancellor keep saying that they can't negotiate with the union. This is between the union and the employers. They know that's not true because, first of all, in 1979, the settlement of the strike was negotiated with the city, with the union, with the companies. We have a signed document, the Mullen Agreement, that put the EPPs in the contract, signed by the Chancellor's office, signed by the lawyers for the city. In 1995, when there was some saber-rattling about the EPPs, Mayor Giuliani put out a press release touting his Deputy Mayor Randy Levine's success in negotiating a contract with the union. And there was press coverage of that. And then finally, last year, after the mayor went on TV with his, comments about a union threat to strike, he took us to the National Labor Relations Board, which found in dismissing the city's case that the city had, no surprise, a 30-year history of involvement in labor relations with the union, particularly with respect to the EPP, found that we have a primary labor dispute with the city, which is why you don't see the city suing us, and also found that we had a dispute with the employers, which is why the charges that they filed with the NLRB this week are very unlikely to go anywhere. So when you want to assess credibility about the legal issues, you should take that context and history into account.
Rick, why did the city all of a sudden, when they argued that EPPs can actually be cost-effective, why did they turn on that argument? Well,
I've never seen any evidence, maybe you have, I've never seen any actual evidence that the EPPs cost money. Now bear in mind, all the EPPs is a master seniority list in the industry, so that when companies come and go in the industry, as they frequently do, the visionaries who started the EPPs back in 1965, and when they were taken out in 1979, that triggered the strike. It sets a master seniority list for everybody in the industry. So if you're whether you're in a union or not, so if you're a non-union worker but you've got 15 years in the industry and you're making $10 an hour, and I'm a union worker who's only got 5 years in the industry and I'm making $20 an hour, you get the next job opening. The point was not about wages. And by the way, there's certainty there because everybody knows what the wages are and everybody knows who's on the seniority list. So a company might actually get a cheaper worker if he's a non-union worker. The point was to create an incentive for people to stay in the industry so that you create an experienced workforce to safely deliver the kids to school. So the city, instead of a low-wage, high-turnover, unsafe transit workforce, which we argued in court costs more money for training and turnover and that sort of thing. The city made those arguments in the case, made them all. We cited to their brief. They just chose not to put any evidence into to support it. Evidence which is easily and readily available based on a 50-year history of the EPPs. What I think the issue is that the mayor, being a businessman and a capitalist, says these contracts have never been bid out for 32 years. That's a disgrace. We should bid them out. Union says, we didn't extend these contracts for 32 years. The city did. You want to put bids out? Put them out. If you can save money by cutting the profits of the middlemen who are the company owners, God bless. Don't take it out on the backs of people who make $14, $15 an hour carrying kids in wheelchairs in New York City. That's all.